Good day, everyone. Welcome to MJ Legal's presentation on partner visas for Australian citizens and permanent residents who want to live in Australia permanently with their spouse or de facto partner. If you, as a sponsor, are still on a temporary visa like a student visa or a 485 or a 482 visa, unfortunately, this is not applicable to you. In Australia, partner visas have broadly three categories. We have the onshore partner visa, the offshore partner visa, the prospective visa. The main differences between them is that the onshore and offshore partner visas require you as the sponsor and the applicant to be in either a married relationship or a de facto relationship. A de facto relationship can be achieved in two ways. The first is de facto by conduct. That is where you have been living together with your partner in a domestic situation for at least 12 months. The second is de facto by registration. There you can just register it just like registering a marriage, but it's a little bit quicker as well. The only state you can't do that in is if you, as the sponsor or the applicant, are living in Western Australia. When it comes to the prospective marriage visa, you don't need to be married to your spouse. However, your spouse must be living offshore or overseas. It's really good as an application if you're still not married to each other, but you're thinking of getting married, say, next year, or if you, as the sponsor, are still married to someone else who you've separated with, and you are currently trying to finalize your divorce proceedings so you can't get married to your new partner. The prospective marriage is great because it gives you the opportunity to lodge the application and have your partner come to Australia once it's processed, and then you have a 9-month window to get married to them or enter into a de facto relationship with them and lodge an onshore partner visa. What you must remember is all partner visas, whether it's the subclass 820 onshore or the subclass 309 offshore, is granted as a temporary visa first, and 2 years from the date of application, your partner can lodge the permanent residency visa. This is because the department wants to ensure that the relationship is genuine and continuing before they actually grant somebody the right to stay permanently in Australia with their spouse. So, what are the requirements when it comes to making a partner visa application? A partner visa application is effectively assessed on four factors. Now, at MJ Legal, when we undertake a partner visa for any of our clients, we help them with all of this. We first help you make a application for a partner visa, and then we lodge the sponsorship application. I know there are many other migration firms, law firms, or agencies that will quote you fees on to lodge the partner visa, and then you have to pay extra to lodge the sponsorship application. But here we do both. And when we do the partner visa, we help you with proving these four factors to the department for a successful grant. We have a 100% grant rate for all the applications we've done. So the first step is to prove that you have an interdependent financial relationship. So things like joint bank accounts, joint liabilities, paying things on behalf of each other would fall into that category. The second step is to prove that you are socially accepted as a couple. So this is photos in social settings, not just the couple, but also with friends and family. Day-to-day communication with each other would fall under the arrangements of the household. And where applicants have not lived together, we have to do this in the form of a relationship statement, which we do up as a statutory declaration. The last one is to show the commitment towards each other. Again, you do a combination of evidence and also relationship statements that shows the nature, history, and development of the relationship. When did you decide to become an exclusive couple, and what your future plans with each other are? So, in proving these four factors, what we usually need to do is we need to show text message communication, photographs of each other, and we also need to have Form 888s, which is a form that witnesses, at least three, but at MJLego we try to do 6 witnesses, need to attest and sign and fill, saying that they know that the couple is actually in a relationship together. So here you can see on my screen all the various forms of evidence you'd like to want to show the department to prove the financial aspects, the social aspects of the relationship, and also the household arrangements and the commitment towards each other. At MJ Legal, when we do a partner visa, we help you draft your relationship statement. We know it's a bit cumbersome for you to do that. So we just ask you to give us bullet point facts of your relationship and we'll draft it for you. So you just need to sign it. We'll also give you lots of sample evidence that you can just take, that you can just look at and prepare your own evidence. We'll also give you sample statements for your witnesses so that they understand what type of things they need to talk about when it comes to your relationship. So we provide you with a full service when we do partner visas, not only lodging the application, but we monitor it throughout, because partner visas take, about 18 months to process. If you're onshore, we help you with the bridging visas. If you're offshore, if you want visitor visas before or after making the applications, we will help you with those as well. And we will respond to all the Section 56 requests for further information that the department sends on behalf of your application. Now, all this time I spoke about people who have straightforward relationships and partner visa situations. That is, if you're onshore, you're on a substantive visa. If you're offshore, you're legally married or you're in a prospective marriage relationship. Now, here is something a bit more complex and only applicable to individuals who are in Australia on a bridging visa. What do you mean by being on a bridging visa? That is, if you have been on a student visa, a 485, or any type of substantive visa, even a visitor visa, and you've applied for some other type of visa, and now you are trying to lodge a partner visa while you're on a bridging visa, the biggest risk to you is that you may be barred by Schedule 3 of the migration regulations. A Schedule 3 bar is a limitation on your ability to apply for a partner visa from inside Australia if you are currently on a bridging visa. So we have helped numerous clients in this situation. So there are some clients who have compelling and compassionate circumstances that prevent their ability to go offshore. For those clients, we have helped them lodge onshore and also done a statement in support of their compelling and compassionate circumstances, because it's assessed at the time of grant, not at the time of application. So we have time to come up with a really strong ground. For clients where we've done an assessment and we believe that it would be beneficial to lodge offshore, we have helped them secure the travel rights and lodge offshore. The process is as follows. We first prepare the partner visa and sponsorship application. Then we lodge a bridging visa B, because if you're on a bridging visa A, you won't have the ability to move to travel overseas. So we will lodge a bridging visa B and first secure your ability to travel offshore. Once you've gone offshore, we will lodge your partner visa. Even if you're going on a weekend, we will ensure that we are available to help you. We will also coordinate with any biometric requirement if the country that you're going to has the requirement for you to do biometrics as part of your visa. Most of our clients just go overseas for 2 to 3 days. They go to Singapore, they go to Thailand, somewhere close by. Then we lodge your partner visa while you're offshore. We bring you back into the country and we help you swap your bridging visa to the visa that you applied, the partner visa you applied offshore. The reason we do this is particularly if you're waiting at the administrative review tribunal for your case to be heard, or you're waiting for your student visa to be granted, you can withdraw those applications, and therefore you wouldn't have to continue to study or waste more time on a visa that is not necessarily going to lead to permanent residency. So at MJ Legal, we have a 100% success rate with all of our partner visas. We take incredible care to prepare the documents and guide you with the evidence. And we monitor the application and update it so that the department will grant it as soon as possible. So if you're thinking about lodging a partner visa and you want a migration law firm that really knows what it's doing, consider booking a consultation with us and we'll guide you through the process and we'll make the application for you so that you can live with your loved one in Australia.